Ladies and gentlemen, I would like to welcome you to the second panel of the 2025 Legal Conference, which is one of our flagship events, bringing together legal experts from all over the world to discuss topical issues related to Europe from a legal perspective. And this year's topic is Europe's autonomy, which could not be timelier given the significant shifts in the geopolitical landscape that we have been facing over recent years, with profound implications for Europe. More specifically, our panel will focus on the autonomy through the internal market and the capital markets union. That is, on the further economic and financial integration of Europe at a time when the rest of the world is fragmenting. Traditionally, we have viewed the internal market mainly as a means to allocate resources more efficiently and foster competition, thereby promoting European prosperity. However, the occurrence of a war in the middle of Europe and the US administration's move towards the most protectionist policies since the 1930s have brought another key dimension to the forefront: autonomy. Market integration is no longer just an economic efficiency imperative. It is essential for ensuring the European Union's economic sovereignty and its capacity to respond effectively to global challenges. And there are at least three dimensions to this. First, deeper integration of the internal market is key to strengthening Europe's economic potential. In an era characterized by uncertainty and unpredictability in international trade, the single market serves as a stable and reliable home base for European firms. As global trade becomes subject to new frictions and Europe's export-oriented economic model is being questioned, we can no longer afford unjustified barriers to internal trade that hamper productivity and innovation. Instead, we must unlock the full potential of the single market. The International Monetary Fund estimates that significant trade barriers persist within the EU. The average cost of selling goods across member states is estimated to be equivalent to a tariff of around 45%, compared with just 15% within the United States. For trade in services, it is estimated to even stand at close to 110%. The good news is that, different from the tariffs imposed on us by the US administration, removing these obstacles lies in our own hands. It is a matter of political will among Europeans without need for third-party negotiation. Second, the internal market plays a strategic role in ensuring the availability and smooth flow of critical goods and services when they are needed most. The European Union has recently adopted instruments to strengthen this capacity. The Internal Market Emergency and Resilience Act, for instance, is designed to ensure the uninterrupted movement of goods, services, and people across the EU during times of crisis. It secures access to critical supplies whenever emergencies arise, which becomes all the more important as such supplies are increasingly weaponized. The COVID-19 pandemic and the disruption of gas flows from Russia after the invasion of Ukraine have illustrated the vulnerability of global supply chains and the economic risks arising from that. In this way, the internal market is not only an engine of prosperity, but also a pillar of Europe's security and resilience. Finally, the internal market is a source of financing, promoting innovation and growth, and providing risk sharing across the Union. The free movement of capital is a cornerstone of the EU's economic constitution. Yet advancing this project has proven complex. In spite of all the efforts over many years, European financial markets remain fragmented and capital is still not allocated in the most efficient way. The goal of the Savings and Investments Union, which includes key projects like the Capital Markets Union and the Banking Union, is to better connect European savings with European businesses, allowing capital to be put at work where it is most productive. One key shortcoming in Europe is constraints to the financing of startup and scale-up companies, the driving forces of innovation, which need far better access to venture capital as well as a liquid European equity market. Overall, this creates a genuine win-win situation for savers, businesses, investors, and the broader economy. Savers earn stronger returns, businesses gain access to financing, investors find new profitable opportunities, and the European economy as a whole becomes more dynamic and resilient. The three dimensions naturally interact. For example, companies require not just sufficient risk capital, they also need to be able to scale up in an integrated market without being hampered by 27 different regulations. And they must have a reliable access to critical inputs. And it is important to remember that, as Enrico Letta nicely put it, Europe is much more than a market, namely a project that fosters unity, peace, democracy, rule of law, and our shared values. In today's world, autonomy is a prerequisite for the European project to be able to continue to deliver on these goals. And I'm delighted to have on this panel three distinguished speakers with whom we will have the pleasure to discuss these issues, each bringing a wealth of expertise and insights into the three aspects. I would like to ask each of you to speak no longer than 15 to 20 minutes so that we will have sufficient time for discussion with the audience. And I will start on my left with the first speaker, who is Catherine Barnard, Professor of European Law at the University of Cambridge. She's a leading authority on EU employment law and the substantive law of the EU. Her extensive work on the legal and constitutional issues surrounding the internal market has made her a prominent voice in the field. Her presentation will set the stage for our discussion by explaining the links between autonomy, the single market, and fundamental rights. Catherine, the floor is yours.
Well, thank you very much indeed for those very kind words. It's an honour and a privilege to be here. I have been asked to talk about autonomy, the four freedoms, and fundamental rights. And I'm hoping that the slides will go up on the... Thank you very much. So our excellent chair has just drawn the threads together between autonomy and sovereignty. Now, the word sovereignty has greater or lesser resonance depending on the state that you come from. For President Trump, the word tariffs might be the most beautiful word. For Brexiteers, it's sovereignty, and for the EU, it's increasingly autonomy. Now, when you're thinking about sovereignty at national level, it's about the ability for a country to set its own laws, control its own borders, work out how it spends its own money, essentially take its own decisions. The advent of EU membership, of course, has shaken all of that. Now, I will return to that point in a moment, but I want to start by thinking about what autonomy actually is. Now, our fantastic host, Chiara, gave a thumbnail sketch earlier this morning, and she absolutely rightly reminded us it has an internal and an external dimension. And while the internal dimension, which is the dimension I'm going to focus on today, the external dimension is much more contested. And for some people, it's about reinforcing the internal dimension. For others, it's about the assertion of the EU's identity on the world stage. But in fact, somewhat ironically, it is the cases on the external dimension that have been used to really unpack what is meant by autonomy on the internal dimension. And I am going to take, one case in particular to focus on that, and that's opinion 2 of 13. So what does Opinion 213 tell us about internal autonomy? Now, in fact, if you look at the judgment, it's almost like everything has been thrown at the wall just to make sure that all dimensions are covered. But essentially on that slide, I've just tried to pull together the various elements. It's the constitutional structure, including the legal basis, which we've heard about this morning. It's about the essential characteristics of EU law, and this takes you all back to your first ever lessons in EU law, supremacy and direct effect, all of this that you know about in your sleep, but also very importantly, fundamental human rights, which I'm going to return to. And then in Opinion 2 of 13, the court goes on to say that these essential characteristics have given rise to a structured network of principles, rules, and mutually independent legal relations linking the EU and the member states, and with the member states with each other. And based on these shared values, of which we now know perhaps most importantly is the rule of law, back in 2013, of course, this was less prominent, there is a mutual trust between member states. And then finally, and very importantly, the judgment goes on to say that there is a judicial system intended to ensure consistency and uniformity in the interpretation of EU law, and referencing in particular that very important dialogue between national courts and the Court of Justice via Article 267. So for lawyers, or certainly for this lawyer, I am taking this as my definition of autonomy. Now, we also know, of course, the concept of autonomy has been broadened quite significantly beyond that, but this is what I should be talking about today. And at the core of that the core of the autonomy is the single market. And this, the court expressly recognises in Opinion 2 of 13, essentially nested within the protective wrapping of direct effect, supremacy, and the other principles I've referred to, is the single market. And as you can see here, I'm not going to read every word, the pursuit of the EU's objectives is set out in Article 3, identifying the 4 freedoms: goods, services, capital and persons, citizenship, area of freedom, security and justice, and so forth. Those provisions are part of the framework of a system that's specific to the EU, are structured in such a way as to contribute to the implementation of the process of integration, which our chairs just talked about, that is the raison d'etre of the EU itself. So how do you connect together single market and fundamental rights? Now, you've already seen how the court had already identified that the essential characteristics of EU law include fundamental rights. But what does that mean? And that's, I would like to use the time that's left to me to make 3 observations. The first, and perhaps the most banal, is that as we've seen, that the creation of the single market lies at the core of the EU structure, and somewhat like Russian dolls, the single market is there wrapped up around with these other principles. But crucially and viscerally, the EU knows that the success of the single market is dependent on the other attributes. The single market would not work without direct effect supremacy and without the full judicial system, which gives effect to those principles. And there are 2 corollaries of that. First of all, there can be no cherry picking, which means that non-members do not and cannot have full access to the single market in a way that a member can, because non-members are not bound by all of those provisions, all of those essential characteristics that I talked about and were listed in Opinion 2 of 13. And even in the case of Northern Ireland, which, dare I say it very quietly, probably does benefit from cherry pricking, at least because it is part of the EU's customs union and single market for goods, even there, of course, under the withdrawal agreement, it is bound by direct effect supremacy, and all of the judicial remedies provisions are built into the withdrawal agreement. So for my first observation is a simple one. The single market and autonomy are intimately linked. You can't have one without the other. My second observation relates to fundamental rights. Now, in opinion 2 of 13, the court is very clear, the paragraph is there, as regards the structure of the EU, it must be emphasised that not only are the institutions, bodies, offices, agencies of the EU required to respect the Charter, but so too are the member states when they are implementing EU law. Now, I imagine everyone in this audience can more or less recite this in their sleep. To put it another way, essentially the Charter and fundamental rights is like writing through a stick of rock. It is there, and now it is robust. We've got the muscular Charter, which the court is using in a vigorous fashion, particularly now Article 47. And indeed, in preparing for this talk, I just put in the word charter into the court's website to see how often it came up. And there were 5,500 references to it. And I decided to stop counting at that stage. Now, the bottom line is charter, very important. Everyone in this room knows about it. We also know that what led eventually to the adoption of the Charter was the concerns about from the German courts about the inadequate protection of fundamental rights in the EU. And we know the story of how the German courts put pressure on the Court of Justice, and the Court of Justice itself then started developing fundamental rights as general principles of EU law, and started to colonize those rights to make them EU rights rather than domestic rights. And as I will show in a moment, I would just say, be careful what you wish for. Now, as far as the role of fundamental rights, we all know that essentially they're used in 3 ways by the Court of Justice: to steer the interpretation of EU law, to challenge the acts of EU institutions, and the area I'm particularly interested in for the purposes of the talk today is to control or limit the activities of the member states when they are implementing, and most importantly, when they are derogating, i.e. relying on the exceptions laid down in the treaties. And there are a number of cases that you're probably familiar with. But essentially what you're seeing is national actions, national legislative acts are being subject to control by the EU fundamental rights. Now, a lot of you will say, well, what's so remarkable about that? The ECHR will control what national systems do, and the European Court of Human Rights adjudicates on that. Essentially, what you're seeing here is also now the Charter being used to control member state activities when member states are acting in the field of EU law, when they are derogating. Now, I'm just going to look at one case, probably the furthest removed from what you do on a day-to-day basis, but you'll see why I'm focusing on this case in a moment. The case I just want to remind you of is a decision in Carpenter. Do you remember Carpenter? Carpenter was extraordinary case in many ways. It was a British man married to a Filipino wife, and she had overstayed her visa. And her brilliant lawyer argued that if she, as Filipino spouse, was deported, that would interfere with his husband's ability to provide services. He very conveniently and very occasionally provided services in the Netherlands to sell some space in advertising journals. And he said if she was deported, there'd be no one to look after his kids from a previous marriage. Now, there is a feminist take on this case, which I'm not proposing to get into, but just so you know, this is already a slightly odd case. Now, court rather remarkably says, yep, there is a breach of Article 56. But the UK says, well, be that as it may, we can justify deporting her on the grounds of public policy. Now, public policy derogation, as we all know, written through the treaty as exceptions to the four freedoms. What does the court say? The court says, well, yes, the UK might be able to run a public policy argument, but it's always read subject to fundamental rights. And those fundamental rights are the right to family life. And as you can see there, they said that there was a disproportionate effect on their family life if she, Mrs. Carpenter, was deported. Now, you might say, well, you know, good news for Mrs. Carpenter. Congratulations to the lawyers. They've done a fantastic job. But brings me to my third point, and this is the point about the risks. And it goes back to the point I made to you about be careful what you wish for. The derogations, public policy, public security, public health, are essentially member states invoking national law, national interests to interfere with the movement of goods or persons or services, as in the case of Carpenter. And of course, these are all laws enacted by democratically elected governments in the member states. And yet they are being subject to no longer domestic human rights standards, but EU human rights standards. And in this case, in the Carpenter case, it was about family life. And of course, the facts were broadly sympathetic. So we probably think it's okay. But I just want to come with a warning. And it may be because I come from the United Kingdom and we are watching the rise of Nigel Farage at a vertiginous rate. But fundamental rights are really under threat at the moment. And the fact that the EU is prepared to use EU fundamental rights in an area of potentially national competence already starts to undermine the ability of states to do what they want when they have very different values. Now, I can see the arguments. The good European argument is, well, look, the derogations are permitted by EU law, so EU rules should apply. But where's the sensitivity to the national interest? And it is quite possible that the review could be much lighter touch. There could be references to margins of appreciation. You could just check that the member state has good reason. They're not using some public policy as some sort of shield for something which is much more malign. But I just want to conclude with a very sad and cautious note, what political scientists call the Overton window. The Overton window is the window about which things can be discussed in public and which cannot. And what we're seeing is that the Overton window, not just in the UK, but in the 9 states who wrote to the Council of Europe, complaining about the European Convention, the Overton window is opening quite dramatically. And unless there is sensitivity about the competence between EU and the member states over something as important as fundamental rights, we may be looking at real trouble ahead. Thank you very much indeed.
Thank you so much, Catherine, for a fascinating presentation. We move immediately to our second speaker, who is Emanuele Rebasti, a highly experienced and knowledgeable legal advisor at the Council Legal Service. He has been instrumental in addressing budgetary matters, including rule of law, conditionality, and the financial architecture of the EU's emergency instruments. And his experience with the new EU instruments, such as IMERA, places him in an ideal position to cover the second aspects that I sketched above. So thank you very much for joining us, and we are looking forward to your presentation.
Thank you very much for the nice introduction, and thank you for the invitation to this prestigious conference. And I would like to continue from where Catherine has finished to give a look through this Overton window, because indeed what we have seen occurring in recent development in the internal market is exactly going into the direction where Catherine sees some future dangers. That is moving from a system where, in case of emergencies, member states are left with the recourse to national derogation, to a system where more and more decisions are taken in a centralized way. And we will see how the crises that have been occurring in recent years were instrumental to informing this paradigm shift. I would need the control. Thank you. So, what I'm trying to present today is how autonomy has become an objective of the internal market. And in the first part of my presentation, I will reconstruct how we did get there. And basically, kind of a spoiler, is through the emergency measure and emergency responses that we had in the recent crisis. They opened the way for a new strand of internal market instrument that have formalized or made permanent a number of mechanisms. And then I will look at the challenges that the inclusion of such new objective, autonomy, at the core of internal market instrument raises. Challenges both in terms of how policy is evolving, challenges in terms of legal issues, and challenges in terms of institutional balance. So let's start from the beginning and look at the phenomenon that is being emergency driven. I don't think we need to go back to the experience we all had during the COVID crisis, when there was big concerns about the possibility to have sufficient personal protective equipment, to have sufficient vaccines, and where the threat was that member states, rightfully invoking the derogatory clauses that we have in the treaty, would in fact completely disrupt the functioning of the internal market and cause a race to the bottom where states that got bigger funding managed to get greater vaccines. And then when this crisis of supply was almost over, a new crisis of supply came in with the Ukrainian war that opened two new fronts, the energy fronts. You remember the first year of the crisis, of the war, where energy was weaponized by Russia, and we had to scramble adopting a number of measures to address the supply crisis. And then, of course, military dependencies that we discovered have been a bit too relied on in recent years. So how did we, the Union reacted to that? I mean, the reaction was one of emergency. And as I've shown elsewhere, the emergency response has been a very varied one. Typically, we think about emergency measure, but it was not just emergency competence that have been triggered. Modification of ordinary legislation, ad hoc specific modification. For instance, in the case of the vaccines, it was necessary to modify the financial rules, the financial regulation, to allow the Commission to procure goods for the benefit of the member states only. That rule did not exist, and joint procurement was only possible when it was also for the benefit of the institution. So it was necessary to modify already back then the financial regulation to allow that. And then, of course, also emergency measures were adopted. For instance, in the case of energy, a number of measures were taken under Article 122 that were aimed clearly at addressing the supply of crisis aid. What is important to stress here is that, of course, the emergency response was ad hoc, was very specific, addressed specific issues, and was a reactive in nature, so lacked completely a preparedness dimension. And all this lesson learned during the emergency phase opened the way to reflection in the aftermath of the crisis, encouraged by the European Council to take the lessons from the crisis and put them in the fabric of the internal market. And so here we have moved to a new setting that is instruments adopting on typical internal market legal basis to include mechanisms that allow the Union to secure its autonomy, and in particular security of supply of certain critical materials. It is very interesting here because the phenomenon underlines a relationship between emergency measure and ordinary legislation, and a relationship that is often lost of sight when we criticize the recourse to emergency legislation in the EU. We forgot often that indeed is not emergency legislation meant to be a single shot or a self-concluded element, but often includes or trigger a normative reflection that involves all the relative actors, in particular the Parliament. This has led to the mainstreaming and the repatriation of emergency solutions, sometimes adopted under 122 and then adopted back on the basis of internal market legal basis. So what is the product of this new legislative activity? Well, there has been a number of new instruments that have been adopted, a lot of them sectorial acts. The CHIPS Act, for instance, that is adopted under Article 114 and 173, that is the industry legal basis, aims at strengthening this semiconductor ecosystem with a measure of market support, but also with a coordinating mechanism for monitoring and responding to shortages in case of shortages of supply in semiconductors. Then the critical raw material acts that also want to address the autonomy of the internal market in relation to critical raw materials, setting benchmark for the production of critical raw materials within the Union as far as possible, the recycling of them, but also introducing a number of market intervention measures, like, for instance, joint purchase of critical raw materials. Then in the terms of defense, we have the European Defense Industry Program that aims at strengthening the industrial base for the production of defense goods, and at the same time is a strong component for addressing crisis situation. The same happened to pharma. And above all these very sectorial acts, we do have IMERA, that is the Internal Market Emergency and Resilience Act, that has a horizontal cross-sectorial approach that is meant indeed to address situation of crisis of supply across the internal market. And in that, to ensure that in all those situations, the availability of goods and services of critical importance is ensured. And in order to do that, establish mechanism for contingency planning, vigilance mode, and then a crisis mode. So what are the common features of this new flurry of legislative instruments? We do have setting up information obligations. I mean, the COVID taught us that Commission or at the EU level, we had no information whatsoever on the existence of stocks and the amount of stocks of critical materials. So the idea is to at least have a knowledge. And then have a focus on preparedness with the obligation to set up a contingency planning, for instance. And then what is very crucial in all these acts, or most of them, is the introduction of an emergency mode that is triggered typically on the basis of a council implementing decision that define the existence of an emergency, and that once triggered, allow the Commission to adopt a number of measures that are measures of market interventions to allow addressing the situation of crisis. And which are these market intervention measures? Well, we do have joint purchasing mechanism. I mean, this is clearly something built upon the experience of the COVID vaccines. But we have also instrument that goes much beyond that. For instance, priority rate requests and priority rate orders, something that the Union realized it was missing when tackling the COVID crisis, and that in other systems, for instance, in the US, exist. So the possibility for the Commission to require or even to have orders that take priorities in the industrial actors over existing orders. So this is affecting directly the freedom of enterprise and economic activity of the companies. And thanks to, of course, the primacy of EU law allows this order to prevail on existing commitments out of private law. And then contingency stock requirements that are more difficult to pass with the member states, but they are still very much discussed, for instance, in the EDIP or in the pharma package are on the table right now. And then an important element, because this is crucial in relation to what Catherine was saying, and we will say it later when we move to discuss the impact for the institutional balance, is that this instrument, in particular, IMERA, contains an obligation for member states when adopting unilateral emergency measures. So all this system, taking a step back from the technicalities, are a way of centralizing action in case of supply crisis in the market. When you read the treaty, this was originally meant to be an area for member states intervention, because that's one of the actions or the scope of application of the so-called derogatory clauses that we have, and we have a few in the internal market, have been interpreted restrictively. But the starting idea was, in case of a crisis, then that goes beyond the ordinary functioning of the market, it will be up to the member states to intervene to protect their own society, health reasons or public security reasons. However, this risk, and the COVID crisis and the energy crisis has shown, risk breaking down significantly the functioning of the internal market. Thus, they need to bring those decisions at the EU level. And then, when we still leave member states' action, we adopt a much more narrowed down and framed framework for their unilateral action. And this brings us, therefore, to the challenges that this new approach or this new objective on the internal market instrument are rising. And then a first set of challenges concern the policy shift. I will not dwell long into those, but I want to underline them. It's clear that we are assisting to a shift from liberalization to interventionism. A lot of these measures actually are market intervention measures that narrow down and not extend the scope of activity of economic operators. One could even say that it is narrow down the functioning of the market, but for a reason, in order to ensure the resilience in case of a specific crisis. A shift from openness to protection, and here I would like just to stress, here we are closing or touching also the external dimension that Catherine was underlining. But a point in that regard is the multiplication of the Buy European clauses. Is one of the issues currently under discussion in many legislative acts where Buy European clauses are introduced, which raises the issue, of course, of compatibility with the WTO rules, for instance. And then let me stress an important point, that is, what are the implications of, it's not just one example, are many, and many others are to come. Here we are witnessing a crisisification of the EU internal market policy. So crisis becomes a new way of defining the scope of legislation. And what is the effect of introducing this element of crisis? Is that actually comes with a number of derogatory measures. And we are derogating, so as part of those emergency toolbox that can kick in when emergency are declared, we have a shortcut for approving permits, for instance. We have regulatory standards that are made softened somehow. We have environmental impact assessment that are reduced. And of course, we also have a presumption of public interest for some of those projects that are declared under those acts, under the CHIPS Act or under the Net Zero Industrial Act, and so on. And of course, we have the regulatory effect on rights, and we have just mentioned the impact on the freedom of economic initiative. Then let's move to the challenges in terms of legal issues. And here, the main issue is how can we incorporate autonomy as an objective or internal market instrument. There are some inherent limitations that comes from the very nature of certain legal bases. I remember, for instance, that industry and health legal bases do not allow for harmonization measures. And therefore, many of the things that I was mentioning would not be possible using the competence that would look more appropriate, the one concerning organization of the industrial production or the one concerning health. According to those legal bases, only coordination measure can be adopted. Therefore, Article 113 has played a crucial role in all those new set of measures. An Article 114 that, have been in recent years been used in an expanded way. So, and the debate that there is in doctrine about this. So the competency creep, the fact that 114 is used to pursue a broader interest or other interest than simply the one of realizing the internal market. And on this, we do have a positive evolution of the case law of the court that has constantly stressed that the pursuit of general interest objective other than the internal market is possible under 114. Provided, however, that the condition of 114 are met. So we do have their own condition, and if those are met, then you can add on other general interest objective like autonomy, for instance. And that's where it becomes, of course, tricky and depends very much into the nitty-gritty of the legislative text. But it is clear that not always the pursuit of autonomy, or for instance, addressing a supply crisis, can as such fit the requirement of 114. 114 is about overcoming disparity that exists or that may exist between the laws of the member states, which are such to obstruct the fundamental freedom or distort competition and therefore hindering the functioning of the internal market. And the measure need to address those disparity of legislation or risk of disparity of legislation. When you look at the crisis of supply, this can be just a market situation, not necessarily determined by the existence of divergence of legislation. Of course, the danger can arise from the measures that are taken by the member states. But that's why all these instruments has to focus not much on the crisis of supply as such, but on the risk that this may have for the internal market and the risk that this may entail of divergent national measures. In that regard, if you looked at the final text of IMERA, if compared to the original Commission proposal, there was an effort by the legislator to put a stronger narrative around the internal market, because indeed the original proposal was more focused on addressing the supply crisis as such. But this is a market condition. 114 is not a provision to create a new market. 114 is an instrument to addressing problem of risk of divergence between member states' laws. Another element, we discussed it already this morning, so I don't want to get back into detail on this, is the relationship with Article 40 and 41 concerning those instruments that deal with the industry of defense, and in particular, crisis of supply of defense goods. And finally, an issue is the one of the relationship with the crisis legal basis, or rather the emergency competencies. Because here what we are doing is basically that ordinary legislation is regulating situation of crisis. So what's the space left for an emergency competence? Well, that's an interesting question, and I will leave it open for the debate if you are interested in this. But I have a final point I would like to make, and it is the impact that these new developments have on the institutional dynamics. Because one interesting aspect of all this crisis mechanism embedded in internal market instrument is the fact that the Council is given a central role in the implementation of internal market instrument. It's something not so common so far, but has been now completely mainstreamed. And it is based on indeed what has happened during the emergency situation and on the emergency measure that had been adopted under 102, for instance. It's typically the Council that adopts an implementing decision declaring the state of crisis that then allows the Commission to adopt one of the measures in the toolbox of emergency that every legislative act establishes. However, it's a bit too early to understand to what extent the Council is going to exercise fully this competence, because this instrument has not really been applied in their emergency mode so far. But if we look at what has happened in the case of emergency measure, it is interesting to know that the role of the Council has been very minimal. In most of the cases, the Council has just confirmed that the proposal that the Commission was putting on the table, but providing, however, a very useful political backing and endorsement to those policy proposal of the Commission. So at the end of the day, actually, even if on paper is the Council who gets more powers, the new instrument strengthened very much the Commission, if not only because these new instruments are regulating matter that so far have been left rather to the member states. And that's my last point. And that's where my presentation goes back to the challenge raised by Catherine. Indeed, this development shows how it's changing the allocation of powers. I mean, through secondary legislation, many of those emergency decisions that used to be left to member states in the form of derogatory act are increasingly bring up to the union level. And that's where maybe the role of the Council is crucial here, because it allows that those interests that were originally the one the main actors of the whole process are still ensured a strong role in driving the response in case of a crisis situation.
Thank you so much, Emanuele. So last but certainly not least, we have Larissa Dragomir, a dedicated European affairs professional with a rich background in commercial law and European policy. Larissa worked at the European Central Bank and the European Commission's Directorate for Financial Stability, Financial Services and Capital Markets Union. And currently she is a member of the cabinet of Commissioner Maria-Luisa Albuquerque. And her intervention will focus on the Savings and Investments Union. So we're very much looking forward to your contribution.
Thank you very much. Thank you. A big thank you to Chiara to bring me back at the ECB after more than 20 years. I was a trainee here a long time ago. I was asked to speak today about the Savings and Investments Union, and listening to the previous speakers, I realized this is definitely a very specific case study of the internal market. We have been with a sort of financial market integration. We have gone a very far way. We have been through crisis. We have discussed all the legal basis, and somehow all this comes naturally. Using 114, maybe Alberto will not agree with me, but it's not anymore as disputed as it was 10 or 15 years ago. Equally, changing the allocation of powers, the direction was given a long time ago, and we have created the ECB in its supervisory capacity as a single supervisor with basically direct powers over entities, supervised entities. We have created the European supervisory authorities. And still, the big flagship initiative of the Financial Services Commissioner, of Commissioner Albuquerque, is getting more integration. The full potential of what we have done over the last 20 years with tens of thousands of pages of legislation, with reallocation of powers, with balancing home and host interests, has not yet delivered to its full potential. And we are becoming ever more of that. And given the current situation, basically, it becomes an imperative to do something about it, or otherwise we risk that everything unwinds or stays in an inefficient way. But I will probably disappoint you today, because I will not be able to give you details of the precise measures that we are going to deliver under the SIU. I will give you more the vision as it was contoured in the SIU strategy that was adopted already on the 19th of March earlier this year, and explain several aspects of it, emphasize basically why a change in approach is needed and is brought hopefully about by the SIU. And deliverables have a short time to be put out. By the end of the year, I hope I will not be contradicted in the approach that I'm trying to present today. And we will keep to basically our determination to move maybe differently than we moved so far. But first, Katrin already said that the internal market and autonomy are intimately linked. I had a bit of problems to think about how to put SIU in an autonomy, in a rule of law debate, because all is so natural and so integrated into the work that has been done on financial markets that we almost forgot the beginnings. But I will try a bit to highlight probably which aspect of the autonomy is relevant from the SIU work perspective. And I don't need to repeat that we are faced with unprecedented challenges. Our economy has been underperforming for too long. We have the green and digital transitions that are a reality. We have defense needs, which are ever more a reality. We have a geopolitical situation that has changed radically, with instability, with unconventional trading policies, with mistrust. And in this context, basically, the European autonomy and the economic and competitiveness of Europe are crucial. We need to be able to care for ourselves. We need to be able to focus on what we can do with what we have and how we can make it better. The challenges have been already highlighted in Draghi's and Letta's report already 1 year ago, and they didn't become better over the last year. I will not repeat them. What is clear is that we need action. We need to make our economy competitive. We need to do this urgently. And one of the things that are required for that is massive investment. There are massive investment needs in several areas that were identified as political priorities. Still in March, the Commission issued the competitiveness compass, where basically these areas were detailed. After that, we had basically the defense action plan. Draghi already 1 year ago estimated that the investment needs of Europe are 750 to 800 billion per year by 2030. Public money is not sufficient. This morning we were talking about budget, we were talking about the constraints to the budget, the limited size of the budget, and it is clear that although there are ways to direct some of our public resources, both at European and national level, into the political priorities, they will never be sufficient to cover our real needs. So private money, private financial markets are essential if we are to really finance our economy and become competitive. We need more investment in the EU, and this means we need a dynamic, and interconnected capital market at the core of our economy. This is the engine that would be capable of mobilizing the savings and channeling them into the productive investments. The SIU strategy, Savings and Investments Union, I will talk about SIU, sorry, for those who are not used to the abbreviation, sets out the vision of a financial market that is functional and efficient and is able to drive innovation, sustain growth, support defense, build resilience. against existing shocks. It is very much about building EU's capacity to finance its own autonomy, its own economy. And this is about the financial autonomy and the financial resilience. I think it's a particular aspect of what Catherine has discussed before as the autonomy, which is so embedded in what we're doing that we're maybe forgetting it. And maybe the new buzzword is less autonomy in the SIU area. It's much more competitiveness also in the context of the bigger debate. But we're talking about the same things, I guess, or I hope at least partly. The SIU builds on progress achieved so far. So what we have worked through over the last 15 years will not go to the bin. It's recognized, it has value, and it builds also on basically what member states have achieved. There are very functional financial markets in many member states. What it is highlighting and it's recognizing as none of those markets is sufficiently big to finance alone the current collective investment needs. So none of the member states is big enough to be able to support the investments needed, which amongst others need a lot of infrastructure, the common, the public goods that you were talking about earlier this morning. None of the member states' financial markets is big enough to stand on its own. A big financial shock that comes most probably not necessarily from us, but from outside, as it came in 2010 and 2008. So progress on integration is needed. We need scale and depth to be able to finance our investment needs. And for that, we really need to scale up our financial services market. We need to integrate it better. So basically, we help capital flow smoothly to where it is needed. The SIU is a horizontal enabler. It requires a change in mindset. So it's not a list of legislative actions only. It wants to be more than that, and we try to basically look at where the current obstacles and barriers are. Why these thousands and thousands of pages of legislation? Why these authorities that we have set up still do not deliver what we expected? Why there is so little cross-border financing? Why we have so divergent applications of the rules? And I would like to probably cover some of the issues that we consider remaining challenges in the internal market dimension. By recalling first that we have done progress on the banking union, where I mentioned the harmonized rule book, the single supervisory mechanism. We have had 2 action plans on capital markets union with around 40 new proposals over the last 5 years, probably, that have been discussed and rediscussed, that have changed legislation. And still our market lacks sufficient depth and scale. Competition across borders is still limited. Domestic specificities remain prominent. Although our financial entities enjoy passporting rights, they are still subject to very different application of common rules, and cross-border activities are too often still treated in silos without the synergies and the risks being properly addressed. This inevitably results in higher costs, limited opportunities, reduced risk-taking capacity, duplications, limited synergies, all impinging on the competitiveness. The IMF has quantified basically these remaining barriers for financial services at 100%, equivalent of 100% tariffs. The consequence is also that the EU citizens, who are among the biggest savers in the world, often forgo opportunities to increase their financial wealth through financial markets participation. The EU businesses too often do not find the financing to scale up in Europe, and they find it elsewhere and relocate elsewhere where they find a much more interesting ecosystem. The structural infrastructure is basically missing in several areas, in digital infrastructure as well as physical infrastructure, because of the lack of size of available financing. This mismatch between savings and investments in the EU was highlighted already in the Draghi report. The quest for financial market autonomy has been always affected by the tension and reluctance to transfer powers to the EU. I said we have gone a long way, but this is inherent to basically any discussion probably of more autonomy and more power transfer at EU level. And somehow there are always ways to find around even the centralization that is imposed through legislation. Let me touch upon some of the institutional and legal challenges that are relevant for understanding and addressing the persisting fragmentation, and which might interfere somehow also with the rule of law principle when applied to financial services. Financial services regulation is the output of a very complex, multi-layered regulatory structure. We have legislation, we have level 2, we have level 3 measures. For those who don't know what this is, it's basically delegated acts, implementing acts adopted by the Commission, often prepared by the European supervisory authorities. And we have guidance, then we have supervisory action. This is absolutely necessary. It's organized, I think, in a democratic way. It's part of the decision making, but it's always leading to a very large amount of rules that are not necessarily consistent and coherent. And sometimes basically they result in contradictions, in a lot of burdening of those who have to apply rules, and in problems actually enforcing those rules. There is little enforcement happening in the financial markets. Moreover, during the rulemaking process, focus is often on building compromise. We were talking about consensus decision-making, about compromise, and this at all levels, from the Commission to the co-legislators to then the guidance, European supervisory authorities, without necessarily looking at the effectiveness. So sometimes due to this very consistent and heavy process, we forget what are the objectives of the integration that we are trying to pursue. Rules are often resulting in language that is deliberately vague. There are proliferation of options or discretions, and there are too often policy decisions that are kicked down the road and left for later and are never taken or taken in a way by those bodies that are not legitimate to take it. Rules are often devised in great detail. They become lengthy legal text. They don't work. They require frequent revisions. We have numbers now to all our main regulatory frameworks that we can hardly even keep track on. Moreover, we are still talking about shared competence, at least at the origins of the financial services integration project, and member states have not forgotten that. And there's still a lot of gold plating happening in the financial services area. Every reason, consumer protection, public good is good enough to basically layer another layer of financial regulation. This is not true for everyone. Some basically use the fact that we are not always enforcing our laws to basically lower the standards and take advantage of regulatory competition. There are member states which do not apply the standards that were commonly agreed to in the way that they were intended. This means that large parts of the financial sector are still subject to very different constraints despite a common regulatory framework and cannot exercise fully their treaty freedoms. There are still many instances of blurred responsibilities, of division of competencies between home and host jurisdiction, especially in cross-border cases that do not work. It's mainly in the capital markets world, but everything is used basically to create more fragmentation where we wanted to create more centralization and harmonization. And last but not least, supervision in the capital markets area is still an exclusive national competence, and at least ESMA has not managed to basically exercise its convergence powers consistently in a way that it reduces the differences in the application of the common rules. And last but not least, in practice, financial services regulation is also intrinsically interwoven with securities law, tax law, company law, insolvency laws, social security laws. These are areas where the competencies of the EU stop or are very limited. So often they are also used basically beyond their own remit to further put barriers into the financial market. The SIU, I was saying, is trying to bring a new approach to deal with this persistent fragmentation. It is considered in the competitiveness compass, it was defined as a horizontal enabler for the EU competitiveness, and it aims to take the internal market to the next level and relies on change in mindset for that. Maybe allow me to present very shortly, I don't know how I'm dealing with time, but some of the elements, constitutive elements of the SIU before I highlight how the SIU may address at least partly the legal and institutional fragmentation challenges that I referred before. So SIU, 2 minutes only. Okay, then I will not give you many details. I will just tell you that the SIU covers in a very holistic, is meant to look at the problems in a very holistic way, which means why do the savings stay in bank accounts or go into US ETFs and are not invested in productive businesses in Europe? What are the reasons? It looks at citizens and it looks at education, it looks at instruments that citizens have to participate in capital markets, and then it goes and looks at the investment opportunities. Why institutional investors are not staying in Europe, why the public money put to support the SIU, sorry, the European economy is not recognized as it is. I'm trying a bit to summarize, so I'm getting a bit confused. Please pardon me for that. So what I was saying, it is basically a holistic approach. It looks at different aspects. Who brings the money? Where does the money need to go? Where is the infrastructure? Why it doesn't work? Where is the role of supervision? It tries to bring everyone on board. It tries basically to have everyone taking responsibility for this. This means that we are not necessarily acting only through legislation. We are recognizing the areas where also under the subsidiarity and proportionality principle, maybe non-legislative action is more warranted. We are looking at ways to have buy-in. Without the buy-in of member states, basically nothing can be, we cannot move the internal market to the next level. We are looking at simplification. Simplification is crucial for competitiveness. Do we really need to go into the details that past legislation has been going into? Can we actually have more principle-based approaches? Can we trust each other? Can we actually move more supervisory powers? Where does it make sense at the European level? How can we ensure that everyone is accountable for their own role in bringing the project forward? And I think I will stop here because I'm getting myself confused, so I don't want to confuse you, but I'm happy to take up any clarification questions and details that I didn't manage to cover.
Thank you very much, Larissa, for an interesting presentation. So maybe I kick off the discussion by asking 2 questions to the panelists. In the meantime, you can think about your question, and I will open the floor. So my first question is, so do you think that it is necessary to allocate more power to the Union in the changed geopolitical landscape, and what are the limits of that? So maybe it's also a question about the link between what you mentioned, the internal and the external autonomy. And the second question is actually to you, Larissa, mainly. So when we ask ourselves why, for example, startup companies are not scaling up, it's not just about a lack of financing, but it's also, as you also mentioned, about a lack of harmonization. And there is this proposal, and it has been around for a long time, of introducing a 28th regime. And actually, I was delighted to see that in this Franco-German agenda that was just published, President Macron and Chancellor Merz actually mentioned the 28th regime. And I would like to ask you, so what are the legal obstacles to that? Because to me, it seems that this, I mean, there are many, like Capital Markets Union, Savings and Investments Union, there are many, many different initiatives. But this one, which is also at least partly in the SIU agenda, for me would be a game changer, a really big thing. So I would be grateful if you could comment on that. But maybe you want to start.
EU lawyers would always like to see the EU having more powers. The big problem is getting there, because the treaties are virtually unamendable now, and therefore nothing can be done. And that's why you keep seeing all these workarounds, because it's almost, legally it's possible, but politically and practically it's impossible to amend the treaties. But there is this undercurrent issue that I was referring to, which is that in some countries, not all, of course, there is an increasing scepticism about the EU. And the simple answer, yes, give the EU more powers to sort out the problems, is not necessarily the right one. So then the question is, what can be done at EU level through EU coordination, rather than exercising powers as such in the traditional sense of passing legislation?
Thank you.
I would say that in the instrument that I've analyzed in the presentation, this transfer of power has already happened. And the trigger was the success stories of the pandemic and the energy crisis. And indeed, to go back to this idea of a normative cycle where crisis is innovation and then ordinary legislation transform and validate those, it's clear that without that experience, it would have not have possible to materialize the results and consolidate them. Is an incremental process. If you look at the number of emergency market measures that are introduced in this instrument, it is somehow more limited than the original list that the Commission wanted to have in those instruments, and reflects more what has been actually already done on the basis of emergency measure. But it is like this that the European integration advanced after all. So this is really Jean Monnet saying that Europe is done through crisis, and that is a good example, a very visual example of those crises then led to a new confer of power to the Union.
And has there been a political pushback to those specific measures, or not so much?
The pushback was against specific measures that were going beyond what had already been done. For instance, I was mentioning it before, but one of the main obstacles, the main resistance by the member states was, on one hand, for priority rate orders. That is a compulsory order given by the Commission to economic operators. This was allowed only in very specific situations, when the industry actually was already part of a program receiving funding from the Union. So the idea is, if we are supporting you via the funding process, then you should be ready also to accept priority rate orders. At least this was part of the EDIP and is not adopted yet. In other cases, this was completely dropped out. And the other resistance was about the creation of a stockage or stock obligations. This was done only for the case of energy, but apart from this, it's not expanded in the internal market yet. We'll see with pharma, because pharma is under discussion.
Maybe also on the first question, it's not a matter of more power to the EU to be allocated on a dogmatic basis. I think we look at it in a pragmatic way, where especially where there is a lot of European regulation, legislation, one legitimately has to ask its question, what is it served? Does it serve its purpose? Why is it implemented so differently? Is the European power transfer on supervision, for instance, in capital markets, a way to address it? Is it good for everyone? Is it good for some? So I think it's very important to say that at least at the Commission, we're not dogmatic about that, and we're taking a pragmatic approach. As regards the 28th regime, it's not part of the SIU. It's part of the bigger competitiveness project of the commissioner. It's Commissioner McGrath that deals with it, so it's in the hands of real lawyers. They will be able to tell you about all the problems of getting there. It's not easy. We're really talking about the systems of member states in areas where the EU has limited competencies. I'm also not always very convinced that this is the absolute panacea, and until this is set up, which will take ages, nothing can be done and integration cannot progress. I think it can. Parts of what could be a sort of EU securities law are also already covered by some of our directives, the financial settlement directive, the financial collateral directive, which are rules, securities law rules that have been transferred in EU legislation. We need more where we see obstacles. But the 28th regime will definitely is now subject to public consultation, so everyone can actually contribute.
Maybe to react to your question, well, there are challenges. I mean, I was mentioning to the limitations that are inherent to 114, and there are at least two big issues that need to address when trying to use this legal basis, for instance, to introduce a 28th regime. The first one is, well, the harmonization. Are we harmonizing when we are actually introducing a new regime? So someone could say we are actually disharmonizing. And the other element is the one of the facultative nature, because this a regime is meant, all discussion around it, to be an alternative for economic operators. And this, again, is conflicting with the logic of removing obstacles. Having said this, I don't want to close the door, because I'm guessing that some creative solution can come out also on the way we use 114, also in relation to the possibility to test additional regime to the one of the member states. But it is not an easy task, and the legal issues are important.
Thank you very much. So let me open the floor. I collect 3 questions. So let me start here, then there, and in the very back. Then I move over here.
I have a question for Catherine. So
can you briefly introduce yourself?
Sorry, Renato Mangano from the University of Palermo. So I have a question for Catherine. First of all, many thanks for having warning us about risk that in the field of fundamental rights, the boundaries between the EU member states' competences are blurring. So my question is, does your warning also imply the warning that there is an over-constitutionalization at national level? Because an excess of constitutionalization of fundamental rights at member states level may have a EU dimension and might interfere with the EU integration. Thank you.
Thank you. Patrick Kanajan. I teach at Goethe University here in Frankfurt at the Institute for Law and Finance. And my question goes to the capital markets SIU question. I think Emanuele is right to have said, and Jean Monnet said it first, that Europe is made up of crises and is the result of how we deal with those crises. My question is, do we see a crisis sufficient to motivate us to move beyond all of the roadblocks to the Capital Markets Union first proposed 10 years ago? Lorenzo Binismaghi has written a number of good short pieces explaining where all the interests are which keep this from moving forward. And is there a way to overcome these? Christine Lagarde had a very good suggestion. The Commission has wonderful ideas. There are 15 or 20 projects in this. Wouldn't it be better to focus on a handful, 2 or 3, and say, this is where we are going to put our power, our persuasion, and not continue saying, oh, and it would be nice to change taxes, and wouldn't it be great to have the same insolvency laws? And by the way, let's do securitization. Thank you.
My name is, I have a question to Ms. Dragomir. My name is Heinrich Nemetsch. I am General Counsel of Scalable Capital. My question is, you mentioned the holistic approach just to eliminate the constraints for regulatory fragmentation. My question is also infringement processes against member states also part of it? Because I'm always puzzled that we have been talking about Capital Markets Union for the past 20 years, and it's still like the same primary goal. When I'm looking at the pass-putting regime, I'm always puzzled that although there's like the single dealer license, if you look at every individual member state has like very specific national constraints labeled as national conditions in the general good. For example, Spain requires institutions to appoint ML officers even across border services. In the Netherlands, margin lending is not allowed to retail customers, although it's not in compliance with MiFID. And if you look at the German regulatory law, half of the national conditions, to me, are not in compliance with CRD and MiFID II. So everyone's talking about it. Nobody is initiating any infringement processes. And the institutions, if they get a restriction by the member states, they will not sue the member state and say, hey, I'm allowed to do it. And sometimes I'm missing these infringement processes to really to get rid of this thing, because ultimately, it always looks to me as if, yeah, of course, single dealer system is fine and harmonization is fine, but not in my backyard.
Thank you for that delicious question. I would actually turn it on its head. My concern is there's an over-constitutionalization of rights at EU level, and that everything is seen through the prism of rights. I think more should be left delegated to the member states so that they feel ownership of those rights and they can prioritize those rights that are particularly important to them. That would create a degree of flexibility. Yes, of course, it would undermine uniformity, but it would create a degree of flexibility, and it would allow the EU to develop rights in absolutely fundamental cases rather than, for example, if you look at any of the cases on social policy now, cases on working time, which is really techie stuff, every single case now is written through with the European Charter. And the trouble is it dilutes the value of rights, because it's quite clear there is a difference between the right to torture and the right to have 4 weeks paid annual leave. But at the moment, they are all being dealt with the same very high level, highly constitutionalized language. I would leave more to the member states. This would be an area where you could actually see the EU backing off somewhat, and you leave the European Court of Human Rights to do the other stuff.
Thank you for giving me the opportunity to talk about the part of my presentation that I missed. So it's precisely about, I think, both aspects somehow. The new approach is meant to pick up actually some specific areas where we will focus our legislative efforts on, and where we think that it's worth like reopening even recently closed frameworks. And this will have mainly to do with trading infrastructure, post-trading infrastructure, and the asset management sector that we consider are basically blocked by a lot of obstacles that often come actually from practice, from national transpositions. We will do it in parallel with enforcement action to the extent that we can build a serious legal case. But we have done a lot of preparatory work to understand where the real obstacles are in practice and which one of those should be prioritized. This means that basically we will focus legislation that will take years, but we are also not sure that this is enough to deliver the full potential. So in the other areas, in particular, where the member states retain still a large competence or exclusive competence, like in relation to supplementary pensions, in relation to tax incentives on savings and investments accounts, financial literacy, we will do more coordination action because it is important that we follow up on this. But there, basically, the responsibility will lay with the member states much more. And I think they have created already for us through the FSC, the EFC, where they report on this. We are trying also to follow up with our European semester and the recommendations. We are working on basically having a much more prominent financial services chapter there to be able to give recommendations and to also cater for the very different situations and developments in member states. But when it comes to scale and depth of financial markets, the focus will be very much on the infrastructure part in the trading and post-trading world. And enforcement is a long work, so it's legal service will probably support us.
So given that we started late, I think we have time for another round of questions. So one right here, one there, and one over there.
Thank you so much, Sylvia Steininger from the Hertie School Berlin and Max Planck Heidelberg. I have a question to Professor Barnard. I'm a big fan, but I fundamentally disagree. My first corresponder would be, so why don't we leave the torture cases to the European Court of Human Rights and focus on labor rights in the internal market? So why do you turn it around? Like, is it the job of the EU to fight torture? Is that actually cases that come? Do we torture people in Frankfurt at the ECB at the workplace? Or how do we distribute the competences here? And following on this, so of course, in backlash research, we know that several cases or judicial cases can trigger backlash or withdrawal. But the problem, of course, is that what is considered an infringement of sovereignty or national autonomy is very different, even in the EU. For one, it'd be trans rights, for other would be the right of prisoners, for another would be, I don't know, German delegation of competence. So how do you accommodate this on the EU level if it's so different what is considered an infringement of autonomy? And secondly, doesn't the European Court of Justice at the moment actually benefit from this confusion with the European Court of Human Rights? Let's just check, for example, the letter that Italy and Denmark have written against the European Court of Human Rights on migration issue, which were actually cases that were decided or were pending before the Court of Justice. The Italy-Albania deal and the ghetto laws in Denmark. So these were not even cases by the European Court of Human Rights, but still the European Court of Human Rights was the bad one. So aren't we just very lucky to have this court and can just do what we please because it will be the bad guy in this sense? So would that not actually speak against what you're trying to do, because the European Court of Human Rights did this and it did not result in any lesser backlash in the last 10 years? Thank you so much.
Thank you. Peter Eckert, University College London. I was struck trying to connect some of the things Catherine said on the case law, on the autonomy of EU law, which stresses the principle of mutual trust, among other core principles of the European Union, and which is, of course, a foundational principle of the internal market and goes back to the principle of mutual recognition. And then gladly hearing from the Commission that there is a realization that the EU is producing very extensive sets of regulations, badly enforced, badly respected by the member states. And isn't the crux of all that we have not managed in the internal market to establish real mutual trust between the member states and their systems? We certainly haven't managed to establish a real
real system of mutual recognition. I think we have as much mutual recognition in practice, the reverse of how much we talk about it in legal academia as a foundational principle. So I was wondering whether particularly Larissa had any comments on that statement. Thank you.
Matthias Lehmann, University of Vienna. I wanted to add a little bit on the discussion on the 28th regime. We have already a number of 28th regimes. People just don't talk about them. We have the SE, Societas Europea. We have the European trademark, the patent. All of these are optional regimes, and they greatly help in overcoming the differences between the different national systems. And we had also a different 28th regime for a long time, which was British law, English law, that you could conveniently agree on and avoid. And it's still, by the way, it's still the preferred legal system for cross-border trade inside the EU. Problem is, it's now outside of the EU. So maybe it's a good idea if the EU comes up with its own rules. And with the French organization Henri Capiton, we have developed a whole system of different 28th regimes. But the thing that we never dared and never touched upon was tax law. Because tax law, we thought, first of all, that the member states will reject. And second, there is a problem with tax law. If you allow, for instance, to choose a European regime, an optional regime for a certain tax or corporate tax, then those founders who are in member states where the tax is higher will obviously all opt into that regime, and those where the tax is lower will never opt into that regime. So it creates an imbalance, and I don't know how we shall understand that the Commission now plans to introduce a 28th regime that also covers tax law. Could you perhaps explain that?
Maybe I start with a trust issue. Trust, I think, needs to be maintained even when it's built. So I think there were episodes when basically trust grows and then one minor accident happens and it falls back. So we need to find a way to maintain trust, and we need probably also the appropriate cooperation fora that are able to maintain trust throughout the years and the evolution of the regulatory framework. So yeah, it can't be regulated, trust. It can't. 28th regime and tax law. I mean, I would add also in the pension sector, we have the PEP, the Pan-European pension product that is a sort of 28th regime, and there are two companies that have set up PEPs in Europe in the last 5 years. So yeah, it's not necessarily a success, and it's largely due, it's in success to the tax dimension. And it's more like giving the same tax treatment to the PEP that would be actually given to national competing products. Yeah, I think tax is on the menu for the 28th regime. My understanding is that we will proceed in an incremental way with the 28th regime, looking first at company law and maybe the easier part where we have even a lot of work done on the European Company Code. Maybe I could mention that under the SIU, we have this concept of the coalition of the willing. So recognizing a bit that we can't harmonize everything, and probably it's not worth harmonizing everything. We actually want to support member states that decide to move forward earlier with common projects. And one of these initiatives has already been launched at the beginning of the summer by the French and the Spaniards on an EU labor for an investment product. And we were hoping that this is a bit of a sandbox, a playground where we see how the 6-7 member states that were around the table could agree on a way to treat this European label under their tax laws. And unfortunately, they did not manage. So they asked the Commission to do something about it and manage and coordinate these kind of very difficult questions. It won't be easy. for sure, but we will not give up until we fail or succeed.
Thank you for your comments. I would say just 4 brief points in response. One, rights talk risks becoming cheapened if everything is a right. I would say that the EU should focus on those fundamental rights that really go to the core of what they do, which is, for example, independence of the judiciary, fair trial, the rule of law issues, which are absolutely quintessential to the values of the EU. I'm not in any way suggesting there should be no right to paid annual leave. You just don't need to call it a fundamental right. I would also say there is a risk of the EU arrogating for itself ever more fundamental rights jurisprudence. Just think about the headscarves cases. In respect of that, you actually find that you're heading towards the lowest common denominator, rather than which is being set at EU level rather than at state level. And some states have much more tolerant regime than that which essentially the court appeared to endorse in the Atchbeta line of authority. And my 4th and final point, I think it's a disaster that the European Court of Justice and the European Court of Human Rights gets confused. I think legally, of course, they have very different jurisdictions. I mean, my own country is the worst. I've often been asked about the European Court of Human Justice, which is a marvelous beast, but shows the deep confusion that exists out there. But joking apart, the attacks on the European Court of Human Rights at the moment, I think, are very serious. And that confusion can lead to further attacks on the Court of Justice, and can also lead, what we're seeing with the Court of Human Rights is the increasing disrespect for the judgments of the courts, even by states that have a long tradition of respecting judgments of external courts. And if you find that happening in the ECJ, the whole system starts tumbling down.
So thank you very much. So fortunately, the degree of confusion in this room has gone down significantly because of the excellent presentations that we've had and the very interesting discussion. So thank you very much to my 3 excellent panelists. Thank you to the audience, and sorry for eating into the coffee break, but I hope it was worth it.